Committee, our last committee before Sonny dies. So we have quite a long agenda tonight, or this evening, or this afternoon, however long we're here. I'm going to ask that Chairman Calzert open us up in a word of prayer.
Please join me in prayer. Lord, give us patience. Give us calm deliberation. Please tone down our enthusiasm and advocacy. Let us be receptive to all of the comments folks may have today and the arguments made for and against bills. Let us just do what our conscience guides us, what we feel like you would want us to do for the better of this state. Thank you for giving us all the privilege to serve in the capacity in the state Senate, and all of those that are here as citizens, the privilege to be heard as we deliberate these bills. Thank you for all the other many blessings you've given us, and help us always be mindful of those more in need and worthy of your love and affection. Amen.
Man, really good words. I think 1 week from now, hopefully nobody will care as much about these things as you do right now, right? But I get it. At the moment, everything you worked for is the most important thing in your mind. And so look forward to working with you all tonight and getting these bills heard, hopefully moving some more good legislation. I'm going to do things a little bit different. Normally the last hearing, at least the ones I've been around, you kind of close by thanking people. But by then everybody's tired and everybody's walking out of the room. I'm going to start by thanking some people. It's been a very busy committee. I kept saying we had 40 House bills. I'm not sure how many original Senate bills we had. Do you remember, Sky? But it was a very busy committee. I think we had a really good year. I want to thank the people that made that possible. Of course, Michael, Legislative Counsel, Ben with Senate Research. Thank you all. Thank you all for doing so much on the fly for us, as always. Appreciate your help with making this process work. We also, in our suite that Kay and I share, have 3 people that work with us this year as aides. We have, you want to stand up, Josh, Bailey, and Olivia. Once again, if y'all please recognize them. For the last hour, they've been having stacks on the floor of bills, and for the last, I don't know how many hours and days, they've been adjusting as we change our bills, working with you all, trying to get this right. And lastly, the person who keeps everything going, sitting to my right, Sky Park, Sky, our admin. I want to give you a little something that Kay... But we really could not make this work without you. And so not only do you take care of all the constituents calling us, all the visitors, but you run this committee. And so we just want to say thank you. All right. Now let's get on the agenda. We'll start, as I always say, if you want to be heard on a bill, please come sign up. We've already taken the sheets. If anybody still wants to sign up to be heard on a bill, please come up here as we start and sign up, so I'll call upon you. We'll start with House Bill 916. And we are working off of LC 490852S. Representative Leverett, come on up. Let me get your mic on. And this is the original version that passed the House.
Yes, sir.
If you'll walk us through House Bill 916.
Thank you, Mr. Chairman, and thank you, members of the committee. I know, as Senator Tippins told Judiciary a few days ago, I'm like a bad penny. I keep showing up here, but I appreciate your entertaining my bills this year. House Bill 916 is the Georgia Superior and State Court Appellate Practice Act, and the chairman has given you the LC number. This passed the House several weeks ago. I know you have a long agenda, so I'm going to be very brief, and we do have some other folks here that could answer any questions that the committee members may have. As a general overview, this bill establishes a single unified procedure for appealing from a lower judicatory to a state or superior court. So usually when we talk about state and superior court, you're appealing from them to the Court of Appeals or the Supreme Court, but they actually, while they're trial courts, they also have appellate jurisdiction over probate courts and magistrate courts and municipal courts and other bodies like that, zoning boards and that sort of thing. So this bill establishes a unified way of appealing to state and superior court from those entities. It's the culmination of years of work that began back in July of 2016 when the Certiorari Review Subcommittee of the Judicial Council of Georgia and the Standing Committee on Legislation Subcommittee was created for the purpose of reviewing the current certiorari review procedure. So when I'm talking about certiorari for the lawyers here, I'm talking about certiorari from a lower court to a superior state court, not the process of going from Court of Appeals to the Supreme Court. This process, as you may know, is very, very archaic. It dates back to the horse and buggy days, and it involves you. It's not just an appeal. You actually have to sue the opposing party and the judge who rendered the decision, and that person has to be served. The judge has to actually be served with the papers and file his or her own answer. So as you can imagine, that's a little bit to ask of an appellant. It also has very old arcane rules that are sometimes difficult to discern, and it generally results in most of these cases being decided on technical procedural grounds rather than on the merits. So one of the goals of this bill is to improve access to courts for people so they can have their cases heard if they don't feel like they had a fair decision or a correct decision below. And it also instills a process where lower judges can get guidance from superior courts and possibly even appellate courts on what processes they should follow. Now, I'm sure you probably noticed that the bill is rather lengthy, but I would point out that it actually reduces the number of code sections governing appeals, so we hope it does sort of make it a little simpler. It makes it uniform, and generally you take the old notice of appeal process that's, I believe, provided in Chapter 3 of Title 5, and the certiorari, which is in Chapter 4 of Title 5, and you would repeal those and replace this with a petition for review. So you basically would prepare the petition, you file it with the court that you're appealing to, not with the court you're appealing from, because sometimes that entity may not even have a clerk. It could be a zoning board or a tree commission, and then the appeal goes from that point forward. So we believe this is would establish, it does take some length, but it tries to answer all the procedural questions you might have about how to bring that appeal, and addresses things like service of process of the petition, getting extensions of time, what the standards of review are, and things of that nature. It is not intended to affect any substantive rights. It's just the process. It's just the procedure. So if the particular court you're appealing to normally hears a de novo review, you've got de novo review in this process. If it's a review on the record, you've got a review on the record in this process. So we believe this just will clarify the law and make sure that people can get their cases heard and have decisions on the merits rather than having them decided on technical issues. This is a rather significant change, and so it has been sort of revised and worked on by the Judicial Council for several years. We also received comments when this was over in the House, and we've tried to clarify and make a few changes, which are already reflected in the bill before you to address concerns folks had. I've gotten a number of calls from lawyers and other practitioners, and I think we've either tried to address their concerns with amendments, or we've been able to show them that the procedure was satisfactory. And the bill does have a delayed effective date. It's not effective until July 1 of 2023. So that will allow a little bit of time for it to sort of percolate and settle out there and folks to get used to the process. So I know Judge McFadden would like to speak to you, and then we've also got Judge Gary Jackson, who is here if you have any questions for him or me, and Darren Enns, who's the counsel to the Judicial Council. If you have any specific questions that I can't call from memory, he will surely know them.
All right, any questions for the author from the committee? All right, we will call upon those that sign up to speak if you want to be heard. Judge McFadden from the Court of Appeals, if you want to step up, Judge, and you can sit tight if you want.
Thank you.
Thanks for joining us.
Thank you. Thank you, Mr. Chairman, members of the committee. As Representative Leverett said, this is a bill to clarify the procedures for invoking and exercising the appellate jurisdiction of the state and superior courts. Its objective, simply put, is to bring those procedures into the mid-20th century. And when I say that I'm specifically referring to the Civil Practice Act and the Appellate Practice Act, which were passed in the mid-1960s. And both of them replaced a maze of various writs and procedures with a single straightforward procedure. In the Civil Practice Act case, one civil action; in the Appellate Practice Act case, a notice of appeal. So it is here a petition for review, which is a relatively straightforward document. be filed in the Superior Court or the state court, because some of the lower judicatories, entities exercising judicial authority over which the Superior Courts have jurisdiction, will not have a clerk as such, or even a clearly identifiable clerk analog. That is the heart of what the bill does. It then leaves it up to the judge to determine what standard of review applies, what remedies are available, and to proceed, again, basically under something like notice pleading. Most of the length of the bill is an attempt to coordinate other parts of the code with it, and our general approach, other than these big picture changes, is not to fix anything that ain't broke. With that, I will, if I may, I'll address any questions you have, and if I may, in all likelihood, I will pass the question along to Mr. Enns of the Administrative Office of the Court. I worked hard on this bill, but he worked much harder, and the real command of the details is with him. So,
All right.
nothing further, unless you have questions.
Any questions for Judge McFadden? All right, thank you. Thank you for your work on this. And does Mr. Enns, Darren Enns, want to be heard as well?
Yeah, I'm available for questions.
All right, available for questions. Thank you. And then we also had Judge Gary Jackson with Atlanta Municipal Court that's with us if you want to be heard.
Yield to the sponsor.
Thank you for joining us.
Thank you, Mr. Chairman. Senator, as a municipal court judge for over 34 years, I can count on one hand the number of actual appeal rulings on the merits that have been rendered on the thousands of cases I've adjudicated. And the reason is 98+% of all appeals get dismissed on technical grounds. In the current lower court certiorari procedure, you've got to get a writ signed by a Superior Court judge within 5 days. Then the sheriff has to serve me personally in open court. You've got so many hoops to jump through that even the lawyers who practice in this field, they're not sure. And the cases get dismissed. And as a lower court judge, I never get feedback. I don't know if what I'm doing is correct, and I don't know if what I'm doing is incorrect, because all the cases get dismissed on procedural grounds, and the poor litigants never get a ruling on the real issues, on the merits. This bill will take work off a Superior Court judge's desk. They don't have to certify anything. It takes work away from the sheriff. They don't have to serve judges. It reduces the appeal section from 39 to 21. And as a trial judge, we get named as a defendant in a lawsuit, and it shows up on our credit rating. When I went to borrow money on my house, I had to get a letter from my city attorney saying, Judge Jackson is not liable in this case, but he's...
That's everyone that signed up to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Calzert, and a second by Senator Kirkpatrick. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. And where'd you go? Is Senator Kennedy going to carry it in the Senate?
I believe he is.
All right. Thank you so much. Appreciate y'all's work on this. Thank you.
Thank you, Mr. Chairman. Thank you, members of the committee.
And come back and see us again sometime.
I'm sure
Just not
I will.
today.
I always enjoy my stay here.
Yes,
Thank
sir. We had one other judge that was visiting with us, Judge Brenda Weaver from the Appalachian Circuit with us. Where's Judge Weaver in the crowd? Back here. Thank you for joining us today. All right, next bill on the agenda is House Bill 371. Is Representative Gunter here? Come on up. So we're going to try to stay in order just for everybody's sake, because it makes everybody's life easier up here if I do that. So I'm going to try to stay in order and how the agenda was set. House Bill 371, we're working off a substitute, which is LC 491002S. I will help Representative Gunter on this and share with the committee. This is the second time this was come up in our committee. The first time we reset it to get some more feedback. What we're trying to accomplish with this bill, this is a whole new subject matter now, dealing with an issue we heard back prior to crossover day from Senator Dolezal, and trying to deal with the issue of having some ability to have some check on the claim of oral contracts, where an allegation is made simply that an agreement exists that's completely not in writing, completely an oral agreement, And his bill originally was going to put contracts under the statute of frauds, meaning that every contract had to be in writing. We realized that was not the way to address this. That was a little too far. And so what we did was we worked with attorneys that practice in the area of contract law who gave a lot of feedback on a draft that instead you see in front of you that sets forth the process in the initial pleading. And so if someone is going to allege an oral agreement, now with this bill, they will have to have, if the only if there's no evidence they have outside of just saying there's an agreement, they have to attach an affidavit with a complaint that'll set forth some other evidence outside their own words that some sort of contract existed. And then once you have that set up, you get into the world where a motion to dismiss could be filed to address a defective pleading, and obviously that allows a plaintiff that's filed in good faith the chance to amend their pleading as well, just to set forth some sort of evidence initially outside just a mere allegation that a contract exists. And in discussing this with lawyers that litigate in this area, everyone agrees that when there's a contract, obviously there's things you have to have in a contract: consideration, an agreement, meeting of the minds, and so looking at what's required in a contract, there'll be some other evidence outside just someone's word that the contract exists. And so we got buy-in from lawyers that work on this too, with the language that we have here. And I see no one signed up to speak, which is a good sign, because last time I put on the agenda there were several people that wanted to speak that had concerns about how it was written. And so unless you want to add anything, I'm going to open up to questions. Do you want to add anything, Representative?
No, I think you explained it very well.
Okay. Is there a question from the committee? Senator Cowser.
Thank you, Mr. Chairman. I wasn't here the last time this was considered by the committee, but so you're basically doing away with oral contracts for worth more than $100,000? I mean, the person obviously filing the complaint, I mean, why have an affidavit saying what I said in the complaint is true? Just verify the complaint. If you have to have some other evidence, you're essentially asking for a writing. So you're just getting where y'all were last time with the statute of frauds, making it be a written agreement.
Right.
That chills people's ability to have an oral contract, doesn't it?
You want me to do this?
Well,
to be fair, I worked on more than he did, so I'll be, unless you want to add anything.
I've not seen the bill.
Oh, okay.
Yeah, let me.
Maybe I should ask the chairman.
I'll be fair. You ought to direct. He can make something up, or you can direct it to me. Senator Cowles, that was not our intent at all. With the language that we have here, as long as there's any sort of evidence, and we use the word plausible claim that such contract exists, this is where you would, with a contract at that level, have to have some sort of other evidence, whether it be money exchange hands, some sort of partial consideration, something you would set forth in an affidavit. And again, the fallback on this too is that if someone files a motion to dismiss because you don't have the proper affidavit, you have the ability to amend your complaint to let the case move forward as well. And so it's an initial threshold. We looked at different ideas. Statute of frauds was too far because you would eliminate oral contracts. We originally, before this, were looking at the idea of having some sort of presumption that a contract doesn't exist if it's only oral, right? We realized that got us in a weird hybrid between where we are here and statute of frauds. And we kind of got back down to this. Again, I tried to put this out there to get feedback from those that practice in this area as well, like I do, I've been on both sides of these things, trying to find that middle ground. And it seems like this is a consensus where if you just say, I have a contract, therefore Senator Cowles would agree tonight to give me $100,000 if I would do whatever. And all I'd have to do is, more than just saying that in a complaint, now I've got to present some sort of evidence of some sort of consideration or just something that's very minimal to survive a motion to dismiss.
Who wants this? I mean, where's the problem? Are there a lot of folks doing $100,000 deals without anything in writing?
Where it came from is there were people in the business community that came forth about frivolous lawsuits. They end up in a summary judgment phase a lot of times, where you could merely under Georgia law just allege a contract exists, and suddenly you get to a point having to discovery, having to get to a point all the way to where you're at a motion for summary judgment. The money that's spent litigating all the way to that point, versus some mechanism to have an initial look at a case to make sure at least it has merit to move forward.
Before a summary judgment.
Before a summary judgment.
I don't need any more questions. I'm not persuaded.
All right. Senator Kennedy.
Thank you, Mr. Chairman. I've got some of the same concerns, particularly looking at line 16. So if I'm reading this correctly, in any action upon a simple contract and parole where the plaintiff alleges the value of such contract exceeds $100,000, the plaintiff shall be required to file with the complainant an affidavit setting forth evidence. So do I understand correctly, the affidavit itself is not deemed to be the evidence to meet the threshold? You've got to have an affidavit coupled with setting forth evidence. What is that correct?
That is correct. You'd have an affidavit that would have some sort of evidence within that. That's right. More than just a verified complaint, which would basically be the same as an affidavit. You'd have some sort of other evidence you could point to.
And what happens if the plaintiff in that case doesn't have other evidence? It's truly just a raw, naked oral contract.
Well, there would be other evidence to be a contract. You'd have to have some sort of consideration, for example.
How do you set that forth, though?
Any other
is that, I guess
claim-
what I'm asking is
Yeah.
that further recited in the affidavit? Because the way this is written, it says setting forth evidence. I don't know if that means something attached to the affidavit or just further reciting in the affidavit.
No, it would be the affidavit itself. And so
Okay.
it could be done by just stating it as testimony in the affidavit, or it could be some sort of other documentation that would show consideration that flowed or something like that as well. Other questions? Senator Jones, is that you? Senator Rett?
Thank you, Mr. Chairman. I think you probably kind of answered the question, but I was trying to figure out, would there have to be some sort of a hearing to determine if you had something substantial?
Yeah, the way this would work, and it's in a motion to dismiss world in litigation. So you'd have a motion to dismiss that would be filed for defective pleading, and then we go to a hearing. But the part that gave a lot of people peace in it as well is motion to dismiss can be filed at different phases of a case. This is very limited. You got to do it at the time of your answer. So initially, you'd have to respond to a complaint by saying they haven't even set forth enough evidence to show there's even a contract here. And so then you'd have what's called a motion to dismiss that gets filed, and the person filing the case would have a chance to then amend their complaint and put that evidence in there, and then the case can move forward. Other questions? Senator Cowser?
I'm sitting here just thinking it through. Why wouldn't this encourage people to breach their oral contracts and dare somebody to prove it if it's just their word against yours? You might be inadvertently inducing people to break their word because they know somebody can't hold them accountable without more than just their own word, and you're not even going to let a jury decide who's telling the truth.
Well, you'd have to survive summary judgment anyway. You'd have to have some sort of evidence of the contract. And so the way this is written, you would have to put forth some sort of evidence that the contract exists outside just saying there's a contract. And you would never get to a jury anyway unless you wouldn't get past summary judgment at that point.
Well, you can.
How?
Why couldn't you now? If I swear that you promised to give me $100,000 if I voted for this bill, and you swore you didn't.
Here's how you would do it. You voted for the bill, right? I mean, so once you voted for the bill, that would be evidence of the consideration that you gave. And that would be all you'd have to show.
Yeah, but what if I didn't? I breached the contract, and you're suing me for that. So you don't have. That's tricky. That's really a poor example, since I know you wouldn't sell your vote that cheap. But
how much are you wanting for this bill, Senator Cowser?
Okay.
Any other questions, Senator Kennedy?
Yeah, one follow, Mr. Chairman. How would you envision if the defendant or the plaintiff was arguing that the other evidence, setting forth evidence, would be partial performance of the defendant? Is merely reciting that partial performance within the affidavit or a verified complaint, does that meet the standard? Or does there have to be some independent evidence of the partial performance, such as some conduct on behalf of the defendant or some other paperwork? And does that then have to be attached to the affidavit to meet whatever the threshold is to be deemed partial performance?
Yeah, and so the standard, the way it's drafted, is the lowest standard. You'd have to have any sort of evidence to support a plausible claim. And so you would not have to go so far as you're saying, is to present. You could set forth the basic evidence that a contract exists, in your initial affidavit. I think the realm you're in probably more in the summary judgment world you would get to what you're saying.
But I'm concerned that the procedure set up here is the defendant doesn't make it, that the plaintiff doesn't make it a summary judgment.
Well, they would have had
They get booted here.
Well, they only would get booted if they had nothing other than saying there's a contract. They'd have to have something beyond just saying there's a contract, some of their evidence.
So let's say they recite partial performance on behalf of the defendant. The defendant disputes it.
Right.
Now you've got an issue of fact that the jury has to resolve.
That's right.
But
that would meet the pleading requirement.
But does it get that far?
It would, because you'd be at summary judgment at that point, or an issue of fact,
But I don't
because
know
you
that
have the pleading.
I don't know that you get to summary judgment. It may get clipped right here if the court looks at it and says, you don't have independent evidence that's beyond what you put in your affidavit, even though the affidavit goes beyond you saying there was an oral contract. That's my concern.
Well, all I know, with this language, if it were to pass, you would have enough to get past the motion to dismiss. And you probably then would get into whether or not there's issue of fact, which in your scenario, there would be an issue of fact if one side says there was partial performance, one side said there wasn't. But here, all you'd have to do is just set forth a really basic affidavit that shows that there is some sort of agreement.
But so if that's the case, then we're back to really an affidavit or a complaint that just says there's an oral contract, and somehow that meets the standard. But the whole purpose of this is that you've got to have more than that. So that's,
Yeah.
I'm sorry, it's just not clear to me where this works and when it doesn't work.
Yeah, so you would have to, if I again go back to my scenario, I say we had a contract, I'd have to put forth something besides me just saying that. I'd have to have some sort of testimony or some sort of evidence in the affidavit that shows there was some sort of performance of the contract, something beyond just me saying it. Senator Hatchett.
And I apologize for just walking in. I was presenting in other committees, but I came in on the tail end of this, but, you know, these $100,000 contracts, and I know contract and parole is one that's not in writing. I mean, that's the definition there. So aren't these most common in like major construction when you agreed on a price, but a certain, I guess, material costs more, so you have to bargain on the phone, and then if you went ahead and bought these materials, that's when, I mean, is that I don't know many other industries where these major contracts are being brought up, but is that kind of what this is looking at? Do you know?
I have not
Yes.
seen the language.
It's not his fault. Senator Dolezal, the story he gave us was a contract that was in the millions. Yet he had a $10,000 threshold in his original bill. And so you're right. We ought to go back, I guess, in all of our scenarios and look at the threshold. A contract where consideration amount is $100,000 or more is where this would kick in. This was the idea of trying to look at it where a contract where money at that value is flowing, there ought to be some evidence of it.
Yeah.
Whether if it's not in writing, which most would be, there ought to be some evidence that that contract happened. That was the aim of this. And thank you for getting me back on track. Where the contract exceeds $100,000, so more than $100,000 is the only time this would even kick in. And so I also get to that scenario where in our whole thing you have to be some sort of showing that the contract had that sort of value even for us to kick in.
And you just have to attach an affidavit.
Yeah.
The plaintiff would swear an affidavit, I guess, presenting certain evidence or attesting that this contract does exist. I mean, that's not uncommon in other areas of law when you file certain
That's right.
medical malpractice cases. You have to have an affidavit from a doctor. Professional negligence, you have to have an affidavit from other people in that profession. So I'm assuming
That's actually where the affidavit idea originally came from. In med mal cases, it's already required. That's where we came to the idea of having a basic affidavit and trying to solve the issue. Other questions, Senator Jones?
Yeah, I just have a couple of questions. So going back, I think the Senator Cowser's kind of example where it is just an oral contract. If you just have an oral type situation and you start saying that it's not going to make it through summary judgment, the question then becomes, you've had discovery before summary judgment. And at that point in time, you've had depositions. And so somebody has been deposed, and the things that they've talked about is either they're going to look credible or they're not going to look credible. And so even though it may just be a quote-unquote oral contract, when you talk about summary judgment, they've had depositions, and it may be a situation where you're like, if you can get them deposed, it will show that the credibility of this contract exists based on certain questions that you can ask them, certain things that they did. But you may not be able to show that in the initial pleadings. And so wouldn't you be kicked out at that time? You might be kicked out the initial pleadings. You never get to that point to get them into depositions, et cetera.
Yeah, and again, the goal of the bill is to have a very minimal standard of what you have to show. And so any sort of evidence sufficient to support a plausible claim would be sufficient in the original affidavit. Obviously, the intent would not be anybody that has the ability to point to evidence of a $100,000 or more $100,000 contract would still have their day in court in doing that. All right. You want to talk about your bill?
Yeah. Mr. Chairman, I just want to thank you for sparing me from having to.
I don't know why I agreed to do it. I will commit to the committee if you want to move this forward. We could work on this as we go towards the Senate floor, if that's what y'all. Anybody else want to be heard on the bill? All right, what's the pleasure of the committee? Motion to pass by Senator Hatchett, second by Senator Kennedy. No more discussion, right? All those in favor of the motion, please raise your hand. All right, carries unanimously. Who's going to carry this? Senator Calzert? I'll carry it.
Obvious choice. Yeah.
I'll carry it. Thank you, Representative Gunter. Next time, be more prepared on your bill if you can. All right. Yesterday it was dogs and pigs in the restaurant. And
Did you see the study committee on them helping puppies?
no.
Yes.
All right, let's get back on the agenda. House Bill 272, a committee substitute. Chairman Ballinger, we are working off LC 491007S, an issue we discussed last session that we have brought back this year. Appreciate your work on this. And with the goal of, with the raise the age legislation, of trying to see if we at least can get this committee started that would work on possible implementation. I'll turn the floor over to you.
Okay. All right. Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to present this bill. If you recall, House Bill 272 basically had two parts. There was the implementation committee, and then there was the actual enactment of raising the age. What we have done is we have basically bifurcated that and just basically taken out the implementation committee, and it's now the standalone bill of House Bill 272. I know the hour is late, and this, you've probably seen this a couple of times now, so I'm just going to run through it really quickly. Lines 12 through 15 establish the chairs. Lines 16 through 28 establish the membership and the committee. Lines 29 through 36 establish interested parties that the committee would need to consult with. 37 through 39 will be the actions of the committee and what they need to be looking into. 40 through 41 would be when the committee is in operation, setting a start and an end date. And 42 through 49 would be the product of the committee, what the committee is meant to produce. And line 49 is the auto repeal, just to make sure that our code stays clean. I'll be happy to answer any questions.
Well, thank you. And you've worked for some time on this issue, and I appreciate your work in the off season with us too, as we try to study this more. And you also mentioned there's a sunset on this, and so this committee gets set up, and then it would be repealed on line 49 by January 1st, 2025. Is that right?
Mm-hmm. That is correct, sir.
Okay. And so we'd be open to, once this committee meets and submits their report, considering legislation if we want. Otherwise, the committee would go away.
Exactly.
Any questions from the committee, from our committee? We have a few people that want to be heard on the bill. I'll start with Carol Maddox, Georgia Interfaith Public Policy Center. You're good staying there, Chairwoman Ballinger.
Okay.
Good afternoon.
Good afternoon. Thank you, Chairman. I'm Carol Maddox with the Georgia Interfaith Public Policy Center and Archdeacon for the Episcopal Diocese of Atlanta. And I just wanted to share with you that we put out a sign-on letter for faith leaders across the state of Georgia supporting Raise the Age. And within a few days, we had over 100 faith leaders from across this state who had signed on in support of raising the age from 17 to 18. I mean, of course, as faith leaders, we're particularly interested in protecting the vulnerable and in reconciliation and mercy to our 17-year-olds who are out there. So I give my thanks to Representative Ballinger for all her work on this, and my thanks to this committee for looking at it. I emailed that sign-on letter with all the signees to each of you this morning, as well as some other leaders. So just wanted to thank you for your work, and please, if we can do whatever it takes to implement this before one more 17-year-old has to go to adult prison for a nonviolent crime. Thank you.
All right, thank you, Ms. Max. Any questions from the committee? All right, thank you. Next, we have Brian Nunez, SP waving. Okay, I appreciate your, I know you're in support of the bill, SPLC Action Fund. Next, we have Polly McKinney, Voices for Georgia's Children. Good afternoon. Welcome back.
Thank you so much. Polly McKinney, Advocacy Director at Voices for Georgia's Children. And while I just want to thank the chair for working so hard on this. We've been working on it for a long, long time. And while this particular bill may not go as far as we would like, it is still movement forward. So we are supportive. And we're here to help however we can. And I'm happy to answer any questions.
All right. You don't have any questions. Thank you. And Ms. Jill Travis says she doesn't have to say it out loud, but Gactel supports the bill. Is that what you want me to say? All right. Thumbs up. All right. Now we'll entertain a motion. Senator Kirkpatrick.
Okay, move to pass LC 49-1007S.
A motion to pass by committee substitute from Senator Kirkpatrick. Is there a second?
Second.
Second by Senator Parent. All those in favor of the motion, please raise your hand. It is unanimous. And who is going to carry it in the Senate?
It's been through so many gyrations. I'm not sure. I'll put Senator Parent on
Senator
the
Parent?
hot
Okay.
seat.
All right.
So.
She said yes. Thank you.
Thank you.
Thank you again for your work on this.
Thank you, members of the committee. I appreciate it.
All right. Next bill on the agenda, House Bill 194, Representative Saines. Another one that came back from last year. But we have a little substitute. So remind us of the bill, but in particular highlight the differences as well from what we voted on last year.
Thank you, Mr. Chairman.
We're working off LC 480624S.
Appreciate it. The original modification was to add a on line 23. The act shall be known as the Georgia Dangerous Sexual Predator. Should say Prevention Act. It just says Act. If it's the pleasure of the committee, I'm open for a substitute to that. In review, Legislative Council did see some technical modifications necessary because the committee changed or passed SB 117. So there was no policy changes, but you'll see that in each instance, there's reference to a list of sexual felonies, and that needed to be updated, so it's just reflective of that. There's multiple modifications to that, but there's no policy changes. So in looking at it, this was based off of course, Senator Kirkpatrick served on the Senate Study Committee to review the modifications that were necessary because of Park v. State in 2019. It modified the powers of a Georgia sheriff to GPS monitor those in the sex offender registry who are level 3 dangerous sexual predators, which is what SORB gives to the most likely to reoffend in the sex offender registry. Very quickly, though the bill is has several pages, the majority of it is listing out each of the offenses. So you see in line 3, it begins with the same construction that you'll see for a few more pages. So line 40, or page 3, line 47 discusses aggravated assault with intent to rape. Page 64, kidnapping. It goes on till page 9, where it lists the offenses referenced for a sexual felony. There was discussion of the bill. We have a mandated life sentence, so what we're asking for is if a offender is twice adjudicated in their second offense, they are much more likely to be leveled a dangerous sexual predator, and that's what this bill is targeting. That individual that's going to likely be leveled, because now we have to have them on a form of probation to allow that GPS monitoring, which is a known deterrent for recidivism. Though this imposes in those very limited circumstances with the high likelihood of that leveling, we put in the bill a 10-year review, and we do that, and we're asking for that to be consistent, not up to a case-by-case basis, because the judge at the time of that second offense does not have the most pertinent evidence that SORB has found to be useful in leveling a dangerous sexual offender. However, we leave it up to the state to come back in lines 309 on page 14. When a probationer is on probation for life for a sexual felony as defined in the code section, DCS shall file a petition to terminate his or her probation if after 10 years on probation they have met those instances, which includes not leveled as a dangerous sexual predator. And again, to be reviewed if they do not meet those instances every 5 years, they're out. That's the majority of the bill. I will say we included on lines 224 and 227 what was requested by GBI at the time but has already been passed by the committee, which is the information on child pornography counting as multiple instances for multiple images. So that, again, I believe could be taken out by the committee if in conflict, or just preferred not to be in there, since we've already passed in both the House and Senate.
For legislative council, is it best just to take that language out if we're going to move the bill? Lines 224 to 227. While he's looking at that, any questions from the committee for the author? And you also wanted us to make the title, this is Georgia Dangerous Sexual Predator Act. That's kind of stuff you bring to our committee.
I would think prevention might be an added benefit in there.
So you want to add the word prevention after predator?
I think, yes, sir, it'd be more notable to the bill.
Okay. Legislative council have any comments? You mean to go on? I'll keep moving. He'll tell me when he's ready. Question of the committee, Senator Kirkpatrick.
Yeah, so the idea was to be sure that the judge had the leveling information that they needed to incorporate that information into the sentence. Is that correct from what I remember from last year?
Yes, Senator Kirkpatrick. This is a very particular bill that's not going to impact a lot of offenders in the state of Georgia per year, but it's the most likely to reoffend offenders that just based on prior knowledge of the criminology of the case, so that they're likely to be leveled. But the 10 years within the prison system and within probation, if that instance requires, is the most useful information, or very useful information to SORB to appropriately level them at the risk level they are.
Well, thank you for bringing that. I know the Supreme Court told us how to fix it, and it just has taken us a while.
Yes, ma'am.
All right, question from Senator Cowsert.
All right, so it looks to me like you take all these sexual felonies and you make them life imprisonment, but you allow part of that to be on probation, but it is probation for life. Is that right?
So in the instance that they're twice adjudicated, so they've already had in one of those listed offenses, and they're coming back and charged and would be convicted of a second of those offenses, then that would be for life with that option of parole for a 10-year period. So after a 10-year review, the court could decide that it's not appropriate for them, and the intention behind that is that they could look at the case and SORB's leveling at that point and make that necessary determination. So in the front end, it is for life, but it would continue to apply only if they met those code sections at the end of the bill.
10-year increments, basically.
Yes, sir.
And secondly, you require them to have some type of ankle monitor or wrist monitor that you're familiar with?
Yeah, GPS monitoring is shown to be, and one of the findings of the Senate Study Committee, shown to be one of the most effective deterrents we have in ensuring that there's not additional victims in this state of sexual predators.
So are there areas that they can't go and a bell goes off if they go in a school or something? I mean, what is the, how do you know who a potential victim is and you're limiting where they go the rest of their life?
So I can speak of the generalities of GPS, but I know that I don't want to throw them under the bus. Department of Community Supervision has experience with GPS monitoring of sex offenders at this time. I think they might be a more appropriate source of asking for the particular information on the effectiveness of it. But it's a relatively understood instance that it is a deterrent for them.
Thank you.
Thanks.
Majority Leader Mike Dugan has joined us. Thank you for being with us this evening. This is my final review to see if I get this again.
It's your probationary period?
Yeah, okay. He always likes when I recognize him. Any other questions from the committee? All right, we have a few people that signed up to speak on the bill. First, we have, two people. Jill Travis, Georgia Association of Criminal Defense Lawyers. You're good staying there. Good afternoon. Or
Good
evening.
afternoon, Mr. Chairman. It's still afternoon
Yeah,
here. It's
barely.
5 o'clock somewhere.
Maybe here.
But maybe here, right. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. I come asking for changes to this bill and ask that you'll hear me out. Senator Kilpatrick, you are spot on because you were on that committee that looked at the sex law changes. And what your committee found was, let me read it slowly. The study committee recommends legislative action to give judges discretion to include lifetime GPS ankle monitoring in a sexual offender's actual sentence by having the leveling information from the SORB available at the time of sentencing. This bill does not do that. This bill does not do that. What this bill does is says, you have a label. It's the crime you're charged with. If it's a second time, if you've done a prior, no matter what the circumstance, you get life in prison. Life in prison means 30 years before you're eligible for parole. Then, let's say you've been a model prisoner. The door opens. Representative Saines thinks that now this is, he's giving this big open door policy that we're going to get off, that the person's going to get off if they don't need to still be on monitoring. Well, that's 10 years later, so we're talking a minimum of 40 years for somebody that could be charged with things as simple as it's not unheard of for a 21-year-old to have sexual relations with a 16-year-old. That's a college senior dating a freshman or a dual enrollment student. The current maximum punishment for that is 20 years. Enticing a child for indecent purposes can be done via sting operations. Not good behavior, right? None of us are condoning this behavior, but it can be not so awful in the circumstances. How about improper sexual contact? The 22-year-old substitute teacher is romantically involved with a 17-year-old student who's not actually his student. That's a life sentence. I agree that they would have had to have been convicted of a felony, one of these other felonies first. It's certainly not, again, it's not good behavior. It's not anything that we would want. But the other thing that's curious about this bill is the absence of knowledge, the absence of even considering that some crimes already carry a life sentence on a second punishment. Rape. Why are we repeating that we need to have a life sentence? Aggravated sodomy carries life sentence. So I agree with the study committee that ankle monitoring is something that a judge should consider. And that's why I would ask the committee to change shall to may on the following lines with regard to electronic monitoring. Those lines are lines 49, 89, 100, 110, 120, 132, 143, 156, 167, 177, 67, sorry, I did out of order there, and 222. In addition, I'd ask the committee to consider changing the shall to may on all of the crimes that don't already have second offense lives. If it's already second offense life, this is really doing nothing anyway. So the ones that I'll name off the crimes and I'll name off the line numbers. Aggravated assault with the intent to rape is at line 47. Trafficking is at line 87. Statutory rape, for any of those of you that have represented people in criminal cases, that statutory rape is one of the more difficult ones. But imagine you've got often a young person involved in that who's now looking at 40 years. So that's statutory rape, that's at line 119. Enticing a child is at line 141. Improper contact, sexual contact is at line 155. Incest is at line 165. And sexual exploitation of children is at line 220. The seminal feeling from those of us in the criminal defense community is we do have a lot of faith in our judges, and we know that just because it says senator in front of your name, it doesn't make you the same senator as the person sitting next to you. Everybody has a different walk of life. Everybody has different circumstances. And what this bill does is it takes the discretion away from the judge and says, we don't care. Judge says, we don't care. The legislature has mandated that I have to give you a life sentence. The wonderful information that's going to come from SORB to the judge, that is really interesting. It's great information. You know what? I'm so glad to see this person is a very low risk of reoffending. But I'm sorry, I've got to give you a life sentence. So yes, we're communicating good information, but no, we're not going to listen to it. We're not going to pay any attention to it. With respect to the question that was raised regarding the duplicative lines in this bill, let's see if I can put my fingers on it. It replicates House Bill 1188. And that's what it's at lines 224 to 227. That was what Representative Saines was saying, is that you might consider taking that out because that's already been passed by this body, at least. Seems kind of anticlimactic to just end on a technical note. So I just want to say I really, really, really wish you would consider changing shall to may. It will make the difference in so many people's lives. Not a ton, because there's not a ton of second offenders, but the ones that need it need to hear it from you.
All right, any questions for Ms. Travis? All right, thank you. Next, we have Robert Smith with the Prosecuting Attorney's Council. Good afternoon.
Good afternoon, good evening. I'm Robert Smith, General Counsel of the Prosecuting Attorney's Council. We've worked with the representative on this bill. We testified last year to this bill. We're still in support, and just want to acknowledge that we're not talking about first offenders. We're talking about somebody who has already committed this offense once, been adjudicated, been convicted, the appeal has been denied, and then if you want to look at it this way, the first time you get convicted of an offense, there's also an educational process that basically this conduct is prohibited, this conduct is not allowed, don't do it again. They then committed the exact same offense, and we're not talking about all offenses. We're talking about a very narrow group of 13 offenses. So it's that you've committed this offense once and twice. this body has already set up in other instances where the commission of a second offense subjects you to a heightened punishment. And that's what this bill does. It carves out these 11 offenses and says, if you get convicted not once, but twice of these offenses, then the court has the discretion to either sentence you to a life sentence in prison or to sentence you to a determinate amount of time in prison, followed by life on probation, and then that can be reviewed every 10 years to determine if that's an appropriate level of punishment. And to echo, this is not someone who would be a low-level offender if they have committed one of these acts for the second time.
Are any questions for Mr. Smith? Senator Parent.
Thank you, Mr. Chairman. Thank you, Mr. Smith. I just wanted to clarify, maybe it's the representative. Does it have to, it doesn't have to be the same offense, right? It just has to have been one of the offenses on the list, because I think your statement was they did it again, but it wouldn't necessarily be the
Yes,
same
ma'am.
thing, right? Am I right?
Yes, ma'am, you're correct.
Okay.
It's they've committed one of these 13 offenses, and then committed another one of these 13 offenses, either the same one or a different one, but still off this list of 13.
Thank you.
Any other questions for Mr. Smith? All right, thank you. That's everyone that signed up to speak on the bill. What's the pleasure of the committee? We do have a quorum. We have 6. We have another committee happening next door. A couple of our members have stepped over to. Yep. What's the pleasure of the committee? Senator Cowser.
Well, if somebody wanted the bill to move forward, I was going to offer that amendment, but it doesn't sound like it's a motion to pass yet, so that's unnecessary.
Do we have a motion to pass in the committee? All right, the bill's not moving forward this time. Thank you. Thank you. All right, next bill on the agenda is House Bill 974. Representative Gullett. We have a substitute, LC 442106S. Tell us about House Bill 974.
Thank you. Yeah, 442106S. This is a substitute bill. 974 requires that the clerks of court offer an e-filing of real estate documents, deeds, mortgages, liens, maps, and plats. And the majority of those counties in the state already do this. They already allow for e-filing. This just, in addition, the additional counties who don't do it would now have to at least allow e-filing for real estate documents. It also creates a standardized page 1 that includes essential data needed for filing by the clerk. I think you'll notice e-filing is more secure, more timely for both the filer and the clerk, and it reduces rejected filings by alerting filers to common mistakes, and generally creates efficiencies in the clerk's office. In this version of the bill, the sub also still allows the walk-in filings as well as the mail-in filings. So it would just requires a quick summary. It requires that all the clerks at least accept e-filing. It keeps in place walk-in filings as well as mail-in filings. And then it requires a one-page, if you do an e-file, it requires a one-page document with some essential data on there so that the clerks can parse through that quickly and let you know if there's going to be a problem before filing it. So it's really an efficiency and accuracy standpoint. Happy to answer any questions.
The version we have here does not make it mandatory that a deed be filed electronically. Is that correct?
That's right. Yeah, the initial one was a mandatory e-file, and I think through the course of legislative process, that's not a good idea, and so this just will require the remaining clerks who don't accept e-filing to accept them, and create a one-pager on the front end of that. It doesn't change anything else. It doesn't change the mail-in. It doesn't change the walk up to the clerk and deliver it.
Right. All right. Any questions for the author? We do have one question from Senator Cowser.
I didn't quite comprehend. How does this differ than the House bill? Was it mandatory in the House bill?
No, the initial bill in the House that I dropped initially required e-filing. You could only do e-file.
Did
and
that
what we
pass
did,
the House?
Well, we subbed it out in Judiciary, and what that did, it required, still required the clerks to accept e-filing, but it also still allowed you to walk in to the clerk and hand deliver it. But it did remove the mail-in process. What this did was this keeps the mail-in process like today. So you can still mail it. You can still walk it up to the clerk, or now you could e-file it. So the difference is in the House version, you couldn't mail in these documents. And in this Senate sub, you can.
Is all of these bills and the remote notaries, they're all just an attempt to allow out-of-state real estate attorneys handle our transactions?
So this is not remote notary. It has nothing to do with remote notary.
Well, it has to do with remote closings. So if you
Well,
pass those two in conjunction, you just set it up, right?
So I don't think it has to do with remote notary and the fact that almost all the counties already accept e-filing. There's a handful that still do not.
So that's who you're aiming this at,
and
that handful, to force them to do it?
That's correct.
Okay.
And then I think an important part that the clerks will tell you is the page one. That's an important part to them on their side. So when they actually are e-filing, they're able to get the accuracy of the information kind of on the front page, so that they can let you know quickly if there's a problem from an expedient standpoint.
And
the reason we removed the mail, I think there's been some priority issues. That's why we did it. Again, there's been some people who don't like that idea, and the legislative process is the process, and so I think keeping the mail in there is the smart move.
We did hear from quite a few closing attorneys that expressed concern with the House version because they would not be able to mail the documents as they currently do. But with your version now, every clerk will at least offer electronic filing, but people can still mail in their filings as they currently do in a lot of places.
That's right. In line 42, for instance, that's just a restatement of law. It's already a law today that the clerks have to have a terminal. We restated that just so there's clarity around that. I think there's some clerks who maybe still don't. And then the language in 45 through 50 is really just to make sure that just because you have information incorrectly on the first page, it doesn't make the contract null and void. That's not the contract. That's just the information up front.
All right. Any other questions from the committee? We have one person signed up to speak on the bill, Miss Amy Huskins with Dwayne Morris. Hey.
Thank you. I'm now in a favor of this after the substitute. Thank you.
Coming to the mic, so yeah, that's what I thought you may say based on your note here.
Sure. I'm Amy Huskins, with commercial real estate lawyer with a partner with the Atlanta office of Dwayne Morris. I've been in touch with a lot of you, and thank you very much. This took care of all the concerns, especially line 40 through 42 that still allows mail-ins, but does offer e-filing in every single county in the state, and that did resolve our concerns of the hundreds of real estate lawyers throughout the state who had this issue. Thank you so much.
We heard from a few of y'all.
Thank you.
Thank you. Any questions for Ms. Huskins?
I'm sorry.
All right, you're good. Thank you.
Okay.
All right, no one else signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by committee substitute, Senator Kirkpatrick. Is there a second? Second by Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. It is 4, 5, 4, so I can count. 4, and all opposed, 1. The motion carries. Who's going to carry the bill in the Senate?
I'll let you know. I honestly haven't talked to anyone yet, so
Okay.
if there's anyone who would love to carry it, I'm happy to have you carry it, but I'll let you know shortly.
Yeah, if you can let me know this evening if
I will.
possible.
Thank you.
All right. Next bill on the agenda, House Bill 1092. Chairman Cooper. The issue we discussed 2 hearings ago. You worked on a substitute with everybody involved. Appreciate your work on this, working off LC 491008S. If you'll refresh our memory and tell us where you arrived on the substitute.
Okay. This is the bill that would allow judges.
Okay, go ahead.
If they decided that a woman that's been sentenced to time in prison, if the judge decided she was not a risk to herself or a flight risk or a risk to others, to have her sentence have her sentence delayed, her beginning of her sentence
in the institution delayed until after the delivery of the baby, giving the mother the chance to have better prenatal care and the baby a chance to bond with the mother. What came into question was, before the bill was a little, to use an old-fashioned word, loosey-goosey, as far as when the judge said that the sentence could start at a later time, who the pregnant lady would report to, and that who would oversee that. And so it's written now that they would be assigned like in when you're on probation, and it outlines all of that. I want to thank Senator Kennedy for sending me to Mr. Skandalakis, who helped me with the revisions on this bill. The bill is still like it was in the beginning, where there is no reduction in time because of your being on probation. If the woman was sentenced to 10 years after the time with the baby, and she started her sentence, it would still be 10 years. There's no time. And it does do some reporting changes that were requested by the sheriffs, and deleted some of the things that they wanted deleted as far as reporting. And I'll be glad to answer questions.
All right, any questions from the committee? Senator Kennedy.
Thank you. Representative Cooper, thank you. We spoke earlier today, and you were showing me some changes that had come from sort of outside your circle. The bill that I'm looking at now, the LC 491008S,
Yes, sir.
is that what we looked at on the floor,
No,
or
sir.
has been changed?
That's been changed with Mr. Skandalakis' supervision. Thank
Okay.
you again for sending me to him.
Yes, he is a trusted source.
Yes, sir, and Robert was very helpful also.
Yeah, very good. So I'm looking at lines beginning with 79.
Yes, sir.
Help me understand. So this says, at the time of the sentencing, and I'm paraphrasing here, of a pregnant woman, when the court sentence includes a term of imprisonment and the court determines that the pregnant woman poses no significant threat to a person or property to the community, the court shall, upon the pregnant woman's request, include a term of probation which shall be served pre-incarceration. So help me understand what do you understand that to mean?
It means that she'll be put on probation, and here again, this is what they worked on with Mr. Skandalakis.
Mm-hmm.
And that what it means is the judge decides she's not a risk, if he's already decided that, and the woman wants to be, to have a delay. And, there is a time when a woman, maybe if there's domestic violence at home, might not want, or the terrible situation at home, the pregnant woman might want to go ahead and start her confinement in the penal system. That it means that she would be appointed a probation officer or supervising person she would report to while she was pregnant and through that period of time before she delivered the baby and was with the baby for 3 months and then for 12 weeks and started serving her sentence.
Okay.
I'm not a lawyer. I'm not very good at this.
No, that's okay. And that was my understanding. And obviously, you've had conversations with the people that you've worked on the bill with today since
Yes,
we
sir.
talked on the floor.
And-
you and I talked on the floor this morning. But I wanted to get your understanding of it because, so I think I'm understanding that there can be probation it would be a period of probation prior to the time the sentence begins.
Yes, sir.
But the sentence still has to be served unless the pregnant woman elects during the time of the pregnancy plus the 12-week or whatever period of time, it can be pushed off or delayed during that time. Is that
That's
correct?
right, sir.
Okay.
That's the only exception.
Okay.
If she was assigned,
Yeah.
if they said her sentence was 10 years, she serves 10 years.
Okay. Thank you. That's very different from what we looked at this morning. And
Yes, it was, sir.
yes, thank you.
So,
Any other questions from the committee for the author? I'm going to call up a few of the people that want to be heard on the bill. First, Mr. Terry Norris, the Georgia Sheriff's Association. Good evening.
Mr. Chairman, members of the committee, thank you, Sharon Cooper, for working with us on this data. I think we have got the data requirements reporting requirements for the sheriffs to a satisfactory state. We were concerned, and I didn't see any work that you had done after we spoke, about the where the data would be reported to. So if I can.
It ended up going to the
Department of Community Affairs
where
is the current
legislative
language.
council put it. I mean,
Well, that is fine, and right now we have a monthly jail data report that goes through GCIC. We had asked for it to come to the Georgia Sheriff's Association. That's where we prefer it to go. I think we'd get better response there, not trying to slow the bill down at all. We can live with the current location of the data to be stored, but we'll get more out of it, I think, from the sheriffs if we do that, and we're doing that now. So if it is the will of the committee that we leave it like it is, we can certainly live with that. But for us and for better reporting, I think we'd prefer it to come to the Sheriff's Association. There's ample precedent in Georgia law mentioning the Georgia Sheriff's Association in terms of training sheriffs, in terms of, for instance, the metal recycler database or registry, which we keep. So we see that this is a good place for it to go. But again, whatever the will of the committee is, and Representative Cooper, Chairman Cooper, we're good with it. Thank you.
Chairman Cooper, if it went to the Georgia Sheriff's Association, that'd still be a place where the data could be shared. Is that your thought on it? Do you have a preference?
yes, sir. I didn't have a preference. I was doing what Legislative Council suggested. I gave him the option. He had given me the option of number one, going to the sheriffs, and number two, the community. And I just gave that to Legislative Council and told them, and they chose community affairs. But I'm fine.
Let me ask Mr. Walker if he wants to comment.
Thank you, Mr. Chairman. Having had further time to consider, I think either would be fine. So if there was an interest in changing it, I can suggest an amendment.
Thank you. All right. Any questions for Mr. Norris? All right. Thank you.
Thank you, Connor.
Next, we have Jill Travis and or Maisie Lynn Girton. Maisie Lynn, Georgia Association of Criminal Defense Lawyers.
Thank you, Chairman. Members of the committee, thank you for another opportunity to address you on House Bill 1092. GACTL has always supported the policy goals of House Bill 1092 and are here today to support this bill. I've also admired the expansive vision and tireless effort women like Pam Wynn and Chairman Cooper have invested in this bill. The dignity that House Bill 1092 offers women and families, not to mention the incredible wealth of nourishment their babies will enjoy as a result, is truly remarkable. We appreciate so much the time and attention Chairman Cooper, Ms. Wynn, and the other advocates have given our concerns, and the significant collaboration that's occurred since we last met with you to vet this bill. We sincerely hope that you'll recommend that House Bill 1090 do pass. Thank you.
All right, any questions for Ms. Girton? All right, thank you. Next, we have Robert Smith with Prosecuting Attorneys Council.
Good evening again.
Good evening.
To reiterate, when this bill came before, there was a statement made that we were going to work with the chairwoman. She's a woman of her word. We worked with her. This is the version that we've come to agreement on, and would ask for favorable consideration.
Yeah, you have a question from Senator Kennedy?
Question. I want to make sure Mr. Smith has the current. Do you have LC 491008S?
Yes, sir, I do.
Okay, great. Thank you.
All right, thank you. We need one more for our quorum, so we're going to be at ease until we get a quorum. We're shifting between rooms, so hopefully it won't be long. Okay. So if you want to sit tight just for a minute.
Okay, thank you. Here.
We can come back to order. All right. 6. That's everyone that signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Rett by committee substitute, second by Senator Kirkpatrick, and a third by Senator Kennedy, and a fourth by Senator Parent, and a fifth by Senator Jones. I don't know. And that's by committee substitute. Do we have any amendments? Senator Kirkpatrick?
Yes, I would like to recommend that we change the reporting from the Department of Community Affairs to the Georgia Sheriff's Association.
All right. And is that the correct name in code? We call it that. Okay, so you'll get that language. First, is there a second on the amendment? Do we have a second? Second from Senator Redd. Any discussion on the amendment? All those in favor, please raise your hand. It is unanimous. Any further amendments? All right, now we have motion to pass by committee substitute as amended. All those in favor of the motion, please raise your hand. It is unanimous. And who is going to carry the bill in the Senate?
Well, Kay has been nice enough or Senator Kirkpatrick has been nice enough to say she would, unless Senator Kennedy would like to carry it because he helped me so much today.
Once again, you're her second choice.
No, please don't do that to me.
You beat me to the punch. I'm gonna let Senator.
It's a lawyer bill.
They're fighting over who's going to do it.
I don't know what.
We'll sort it out.
We'll sort it
You all
out.
sort it out and let me know.
Thank you, and thank you to everyone that worked on the bill.
I'm almost used to it by now.
I'm not. Am I red in the face, sir? Thank you very much to the committee.
Thank you.
Thank you.
All right, we're almost there. House Bill 1274. We are back with LC 490947S. This is a bill we heard, I think, 2 weeks ago, if I remember correctly. Chairman Carson, is this the exact same bill we heard last time?
It is yes, sir, Mr. Chairman. It is the same committee substitute that was introduced two and a half weeks ago.
Yeah, and part of that is we did not allow public testimony on it because this is the second hearing, but I want to make sure everybody's clear this is the same bill we took testimony on last time. I know
Yes, sir.
all of us, I think I speak for the whole committee, have met with people on both sides of the issue since that time, and I told you I would give you a chance to come back and make your case for the bill. That said, I'd ask if you can try to keep your
Comments brief.
presentation as short as possible.
Absolutely. Thank you, Mr. Chairman. Members of the committee, appreciate your indulgence. What this bill does, House Bill 1274, and just for everyone's clarity, I'm working on LC 490947S. What this does is codify a definition of anti-Semitism from the International Holocaust Remembrance Alliance. All this does is ensure that when analyzing the intent behind illegal discrimination actions that target Jewish people, whether it's a hate crime, illegal discrimination, what have you, that there is an allegation that when there's an allegation that the action was motivated by anti-Jewish sentiment, authorities consider the world's most well-accepted definition of anti-Semitism. This definition from the IHRA has been officially adopted by 865 different governmental entities. I wanted to mention to the committee that Iowa has now passed this into law. Tennessee is actually hearing this right now. Also, bills just like this are pending in Arizona and New Jersey, and South Carolina has passed this by budget proviso. This bill does not limit, and it's very important to note this bill does not limit in any way anyone's freedom of speech or expression. It does not create any new protected class, enhance any punishment or regulate or restrict academic freedom. Anyone can say whatever they want, however awful, about Jews or the Jewish state. Anti-Semitic speech is constitutionally protected as a First Amendment right, and this bill does not attempt to change that. You can see that in the bill sub on lines 51 through 54 on subparagraph C in regard to the First Amendment protections there. This bill is necessary, Mr. Chairman, members of the committee, because the Jewish identity is so potentially multi-pronged, multifaceted, incorporating aspects of religion, race, culture, national origin, and ethnicity, that without a standard definition is easy for anti-Semites to hide behind the ambiguity thereon, committing anti-Semitic acts, then claiming that it was not anti-Semitism because it was not based on this or that particular characteristic. This bill is important because while Jews make up 2% of the U.S. population, according to FBI 2009 hate crime statistics, they account for over 60% of all hate crimes directed at a specific religious group and 13% of hate crimes overall. And these numbers are increasing, unfortunately, despite the monstrous prevalence of anti-Semitic incidents. Nearly half of all Americans say they have never heard of the word of anti-Semitism, or very few know what it means. We have a number of groups that are here in support of this, Mr. Chairman. Unlike last time, where we didn't feel it was quite necessary at the time. The various groups locally and nationally in favor of this legislation are the American Jewish Committee, Atlanta Israel Coalition, Atlanta Rabbinical Association, B'nai B'rith International, Hadassah Greater Atlanta, Hillels of Georgia, Israeli American Council, Jewish Community Relations Council of Atlanta, Jewish Federation of Greater Atlanta, National Council of Jewish Women, National Jewish Advocacy Center, Zakor Shoah, and various synagogues. I'm not going to have them all speak, and I know that's not allowed, sir. I just wanted to, if you're a member of one of those groups, if you could just raise your hand very quickly for the committee, I would just very much appreciate it. I really hope there's some people raising their hands, sir. Can I raise my hand to the Baptists or in support? Okay. That's we've covered this bill before, and that's a high level overview, sir. I have the definition of the anti-Semitism as per the International Holocaust Remembrance Alliance. With that, Mr. Chairman, I'd ask for the committee's favorable consideration.
Or you have a question from Senator Parent?
Thank you. Thank you so much, Representative. We had some discussions, I believe, in the last hearing raised, I think, by Senator Hatchett about perhaps the appropriate place for the legislation was within Title 17. Did those conversations go anywhere? Did you consider that?
We took that feedback. We believe that Title 50 is the appropriate place because Title 17 is really limited to just hate crimes, which is typically a violence or what have you. Title 50 covers general definitions, and that would apply to discrimination in the workplace, discrimination in regard to hiring and firing, discrimination in regard to housing, discrimination and other anti-Semitic acts in regard to school campuses, state universities, and so forth.
So you think, I'm sorry, follow up, Mr. Chairman?
Good.
So do you think that this is the only appropriate group to apply such a statute to?
To my understanding, if it's in Title 50, it can be used as a definition of anti-Semitism that's not limited to hate crimes, but it would be a definition that could be used in those other instances. Yes.
I guess what I was, what I meant was, do you think that we will need to consider adding other groups to this more, especially since it's not in Title 17, which means it's not limited to the work done on hate crimes?
Right.
So when in not doing that, then you open up the broader question of acts of discrimination against many other groups in our diverse society. Like how do you propose we handle those? I guess the question.
I can't speak to that. What I can say is, like I said, the Jewish identity is, and the Jewish people are so multi-pronged, multifaceted, that's what's driving the need for this legislation, rather than just I commit a violent act against a Jewish person. That would all be obviously covered probably with regard to Title 17 and hate crimes. This covers general discrimination and in Title 50, because if I were to say I'm going to discriminate against somebody based on the color of their skin, that's pretty identifiable. If someone is pro-Israel or Jewish, that could be it could be religion. It could be related to religion or race or culture or national origin or ethnicity or what have you. It's multifaceted. It's the best way I know how to say it.
Thank you.
Senator Kirkpatrick.
Yeah, I just, it's been a couple weeks since we looked at this.
A long couple of weeks.
Yeah, and I just wanted to refresh my memory about why it's better not to put the actual language into code.
Yes, ma'am. Thank you for that. We actually had this very conversation in House Judiciary, and it's because we want to refer to a definition that is internationally accepted. Senator Parent, you actually had this very same question, if I may. And the reason we're doing that is to be very clear in our state statute that we're referring to an internationally recognized definition. However, we're referring to that definition as of a certain date. May 2016. So if the International Holocaust Remembrance Alliance, IHRA, comes back and changes their definition, doesn't matter. We're referring to this as of May 2016. That way, we're referring to an internationally accepted definition. However, we're only tied to that definition as of a certain date. If they go back and change it, then that would not apply to our statute under this bill.
Question from Senator Jones.
Yes, thank you, Mr. Chair. So I guess going back to what Senator Parent was asking, when we say that, race is more identifiable, easily identifiable, and I guess we've kind of had this conversation before. But so one of the things I wanted to do was kind of research anti-black racism. And so even though these definitions are not worldly accepted, these are some of the definitions that come up. Anti-black racism would be fighting against access to African-American differential access to health care. Well, would that just be simply saying that you're opposed to Medicaid expansion? Would then you be black? This is what these commentators are basically saying. So it seems like race is as easy as it is, we just want to discriminate somebody on their skin color. But it actually is more than that. So when we go a little bit further, anti-black racism means that you have to fight against housing discrimination and redlining. But that also may be as simple as just zoning ordinances. Okay. When we start talking about anti-black racism, being that we have to acknowledge that black racism, this is the definitions that were used, that black racism goes deeper than any other racism in the United States. How do we codify that? See, that's where I get kind of concerned. And let me just say this. I agree with what they're saying. I agree that when we talk about redlining and things like that, race plays a part. I agree when we talk about lack of access to health care, race plays a part. And some other colleagues may not. But the question that I have is, how do I codify that? How do I make that something the public can actually follow? And why not just have it under the rubric of just racism? And we use that definition because once I decide, I want to do anti-black racism, but I'm not going to do anti-Hispanic racism, or I'm not going to do anti-Native American racism, I'm just picking and choosing at that point in time, am I not?
I see your point. I can't even imagine how much, to me, how many people this would touch. What you're talking about in a deep personal way. I don't know how to speak to it further than that, sir. I really don't.
Thank you, Mr. Chair.
But I appreciate your comments.
Any other questions from the committee? All right. With that, we're in a posture. What's the pleasure of the committee? Motion to...
Second. Motion to pass.
You want to say it in your mic. Motion to pass by Senator Kirkpatrick. Is there a second? Second by Senator Redd. Any discussion? We have discussion from Senator Jones.
Yes, sir, Mr. Chair. Just to reiterate my position on it is that I'm, opposed to all racism and probably one of the more liberal members on this panel and in the Senate. I just think we're going down a road that I can see where we're heading. And as I said, I agree that redlining and zoning issues have racial tinge. But how do I codify that? How do I say that that's anti-black racism and therefore you now are in violation because you do a zoning ordinance? How do I codify if you're against Medicaid expansion where some commentators are saying that's anti-black racism? And it's real. And those questions are real. And they're things that we're going to have to face in our pluralistic society. And I just think we're heading down a path of somebody who actually agrees with a lot of these things that are said. I don't know how we codify it from a legal standpoint to one we can argue in court, not in a classroom, not even on this panel, but within court. And that just gives me grave concern.
All right, any further discussion? Or we have a motion to pass on the floor. All those in favor of the motion, please raise your hand. We have 6. All opposed, 1. The motion carries.
Thank you very much, Mr. Chairman.
Who will be carrying the bill in the Senate?
Chairman Calzert and I have spoken. I think as long as I get a nod from him right now, he's okay to carry this on the floor.
Chairman Calzert will be carrying it. Thank you.
Thank you.
Thank you
very much, the committee. Thank you.
Thank you. All right, a couple more. House Bill 1354, Representative Holcomb. We have LC 442038S as passed by the House, Wrongful Conviction Compensation Act. Give us 1 second to get the room cleared out. All right, let's get back on House Bill 1354, LC 442038S. Floor is yours.
All right. Thank you, Chairman Strickland, members of the committee. It's my pleasure to present to you House Bill 1354, which is the Wrongful Conviction Compensation Act. Let me start by beginning to say that this bill, just to orient you to the policy, I know you've had a very busy day, is for a very, very small universe of people, and it is only for people who are innocent, were wrongfully convicted, and then were incarcerated. And it is to set up statewide policies to provide for compensation of these individuals. Overall, our criminal justice system works, and it gets the right answers, and it convicts the right people. But like all human organizations, it's not perfect. And unfortunately, there are times when innocent people are convicted and then spend significant periods of time in jail. The way that the process works now is it is an ad hoc process where an individual has to file a claim with the Claims Advisory Board, which is housed underneath the Secretary of State's office administratively. They have to find a legislator to sponsor a resolution, and then that legislator has to move that resolution through the legislative process. This year there are 2 of them. One of them is for Dennis Perry, and then the other one is for Kerry Robinson, and I am the sponsor of that measure. Both individuals were clearly innocent but were convicted. Mr. Perry spent 20 years in prison, and Mr. Robinson spent 18 years in prison. So the idea behind this proposal is to set forth statewide policies and procedures to take this out of the hands of the legislature in terms of it being a political process. So what it would do, and the meat of the bill starts on page 3,
is it would set up a wrongful conviction compensation panel, which would include experts. The key part of it is that this is only for innocent people. This is not designed to help those that may have been released because of a technicality or a suppression of evidence or something like that. This is for truly innocent people. The way that that likely is going to be determined is going to be some video evidence, which maybe was concealed and then was released down the road, or DNA evidence. The state has invested a lot of money into DNA. Among other things, we've made great advances in reforming our system and processes for the handling of sexual assault. One of the statements about those efforts has been that we can use DNA evidence both to identify the people that perpetrated these crimes and also to use the DNA evidence to exonerate those that did not. In Mr. Robinson's case, that's exactly what we have. So the definition of exonerated is very tight and narrow. It's only those that are exonerated, meaning that they did not do it. That's on page 3. The individuals who would be on this panel are listed on page 4. They would be an individual appointed by the Chief Justice, a district attorney appointed by the governor, a criminal defense attorney appointed by the governor, and then an individual. The idea behind this is to get some expertise, an attorney, forensic science expert, or law professor with expertise in wrongful convictions, with one appointment by both the Speaker of the House and the President of the Senate. They would then make a determination of, is this person innocent? Evidence would be presented at a hearing, and then the individual could not be convicted of any lesser included offenses. And so if there's, say, an exoneration on the highest charge, but then you're convicted for a lesser included offense, this would not apply to you. Again, this is only for innocent people. And then the bill provides for a range of compensation, and this is on page 7, beginning on line 141. The range specifically can be found in lines 147 to 49, and it's between $50,000 to $100,000 per year of incarceration. The national average is $70,000, so this gives the panel an ability to reflect on the facts and circumstances relevant to the case in front of them and to then make a judgment. Going on to the next page, the manner in which this would be paid out would include an annuity. This was a recommendation from the chairman of the Appropriations Committee in the House, and the annuity could be, or the cash portion of the payment could be up to 25% of the award, but then there would be an annuity for the rest of it. The annuity's length would be contingent on age. If it's under 60 years old, it would be 10 years. If it's over 60 years, it would be 20 years. And then ultimately, this recommendation would be a written opinion from this panel of experts to the Chief Justice, and then the Chief Justice would then make an appropriations recommendation to the General Assembly. And I view that, and others share this view, that would be an administrative task by the Chief Justice, would be to oversee this and then to make the official request for monies. The idea behind that is the error occurred in the court system, so it makes sense to have it be within that part of the budget. This bill is bipartisan. Chairman Efstration worked on it very hard, and it also has the support of Chairman Houston and others, and I'd be happy to answer any questions if the committee has them.
A question from Senator Kirkpatrick.
Thank you, Mr. Chairman. My question is about lines 150 through 153 about attorney's fees.
Mm-hmm.
I just wanted to understand if that could potentially go all the way back to the original case.
It could. We had a good discussion about that in the House, and the idea behind it is my sense that the application of this would be very, very rare for a couple of reasons. One is most individuals for whom this would relate to will likely have public defenders, and then they will also probably have pro bono lawyers helping them in terms of the compensation process. However, and we thought this was important, was if an individual did not do it, and there was, this is rare, but it has happened, prosecutorial and law enforcement misconduct, and an individual has to spend his or her money to fight that, and the system truly was rigged against them, we thought that it was warranted to have at least an option for the panel to be able to include attorney's fees as something that could be compensated, because they never should have been arrested, they never should have been tried, and they never should have been convicted to begin with. So my sense is the application of this will probably be rare, but we thought that it was important to include.
Just follow up. So because you said may, in that language, it gives discretion to the panel to decide that?
Yes,
How
ma'am.
far back it would go?
Exactly.
Thank you.
If at all.
When we discuss this, and I'm discussing with some of my colleagues, may want to, I know we have questions now, may ask some similar things, but you know, there's been some concern when we do this, whether or not it should be based on someone's claim of innocence or should it be based on some sort of misconduct on the part of the state. And I know the part of the bill that really is the meat of this, lines 97 through 102, talks about what a claimant must establish by preponderance of evidence. And you do base it, you said this was, to me, this is based on innocence.
Correct.
This is not based on any sort of misconduct on the part of the state. Two questions. One, why? Why is that where we're going with this? And then two, if we, in the current process as it's set up, that you mentioned through the, I think you said in the Secretary of State's office, what is the standard there? What are we currently using versus what you're doing here?
Okay, thank you. I'll work backwards and answer your second question first. The current process, I think the people that work on it, on the Claims Advisory Board, they would readily tell you that they don't like the process and that it really doesn't fit for them to be making these decisions. The types of decisions that they usually wrestle with is if a DOT truck hits somebody or something along those lines. They're not really equipped to handle these sort of complicated, justice-oriented questions. And what happens is they'll listen to the evidence. They're all designees. They're typically designees of the agency head. The agency heads themselves serve on the committee, but they usually task somebody with that responsibility. And then they listen to the evidence, and then I don't know that there's ever been an instance where they've ruled in favor of the claimant, but instead they will write a report that is very favorable to the claimant, saying, we believe this person is innocent. We believe that this person spent years in prison and they shouldn't have. And then they'll say that there are very compelling reasons that the General Assembly should consider doing a resolution and moving it forward. And I'm new to this. It was brought to my attention in the fall. And I'll just tell you, to the extent that this is helpful for any of you, I did not immediately jump at this. I'm a former prosecutor, and my own biases, I had trouble getting to accept what I sort of stressed at the beginning, is that these are innocent people. Like, my own reaction to it was I had trouble immediately comprehending that we're talking about truly innocent people. But that is what we're talking about. People that never should have been arrested, never should have had to sit through a trial, and never should have spent a day in jail. And so with that, I'll segue to the second part of the answer to your first question is, I think we have to make a policy choice, and I would argue for the policy choice of, if you are innocent and your liberty is taken away, that should be compensable. I understand that there are people that may not completely agree with that view, but what I would suggest be considered is, one, every case that the state brings is state v and then the person's name, and then the state is the entity that is locking up these individuals in our Department of Corrections, and it's state taxpayer money that's resulting in this loss of liberty for the time period at issue. So I think that the innocence is the right metric and barometer, and I think that making it anything other than that, such as purposeful misconduct, just really kind of complicates it. And I'll also say that we're not making the decisions, but we're setting an architecture for these decisions to be made. And we're already kind of doing this. We're just doing it from the General Assembly. And I think this is just putting better guardrails in place to help make decisions that are already happening, if that's helpful. And hopefully I answered your question.
And the last question I have, then I'll turn it to others. For us as legislators, we obviously currently have a check on this through the process we have now, the political process, if you will, of the bills coming, the resolutions coming. This goes ultimately, after decision is made, into the budget for the Chief Justice of the Supreme Court. And my question would be, is the intent that would still be the check that the legislature would have if we were to go in and think this group messed up and the amount's not proper? We have the authority to oversee where those funds go.
Absolutely, Mr. Chairman. That's a great point. And those checks and balances do exist because ultimately it's going to be subject to appropriations. So we will get a report which will be far more detailed than what we get now with a group of experts that will help us make this decision with a recommendation. They're going to do the heavy lifting, and then it's up to us whether or not we want to agree with that. And if so, we can appropriate the monies, and if not, then not. But there's no requirement for the monies to be appropriated. It's just to help us make that decision better.
All right. Is that who's 11? You? Scouser. Okay. Any other questions from the committee? Senator Kennedy.
Thank you, Mr. Chairman. Representative Holcomb, thank you for bringing this. This is very thought-provoking, and you're right. It does force us to deal with some very difficult things. And I think along the chairman's questions, for me, if this were a matter of the standard included prosecutorial misconduct or the state doing something wrong, I'd be more inclined, more interested in sort of going through this and maybe down this road. But that's part of the concern that I have. And you addressed that in your comments. And I think you said that was one of the metrics you sort of thought about in approaching this. But I have difficulty with it. As attorneys, we were talking, doing civil work. If what we're talking about, and you're right, they're innocent, but they're innocent because of no fault of the state, but in short terms, the jury got it wrong, right, in essence?
Maybe. And here, maybe some context will be helpful in thinking about that question. Take, for example, I always try to fight against the notion that sometimes takes hold, which anecdote equals universal truth. But with that, if you take, for example, the two resolutions from this year, Dennis Perry demonstrated misconduct that led to his conviction. I'm not the author of that, so I don't know the details, but I know that that is the case, and it's demonstrated. For the one that I'm helping, I don't know that there was purposeful intent of the state getting it wrong, but the specific as to what happened is that there was, I have to give you the factual picture. It was a very brutal sexual assault with 3 people. The primary person was identified by the victim. That primary person then identified 2 people that were not part of the rape in order to protect the 2 people that were his friends. He was given credit by the DA for identifying the other people, so he would be what would be known as an incentivized informant. That requires corroborating testimony. The corroborating testimony was given by the GBI. I love the GBI. I think we all do. They do really important work. They work very, very hard. But in this case, the testimony, and this is almost verbatim, the GBI agent testified that I can't do the math, but it's a very, very, he used the word very twice, it's a very, very low probability that anyone other than Mr. Robinson committed the offense. And he was convicted on that. It was a wrong reading. He didn't do the math, but because he testified on that and was the expert, that was the corroborating evidence that led to Mr. Robinson being convicted. When the math was actually done correctly. Mr. Robinson is African American. The correct analysis is that a random African American on the street is 1,800 times more probable to have committed that crime than Mr. Robinson. So in that case, the state did play a role, did make a mistake. Do I think it was intentional? No. I'm going to infer benign intent on the part of the GBI expert. But I think if we drill down just in the two anecdotal situations that I gave you, I think it's difficult for me to come up with a fact pattern, particularly on the fly, to where there wouldn't be some state error, purposeful or not purposeful, that ultimately leads to the conviction. And so because of that, I don't think you're going to just get randomness of people. And I'll also submit it's really, really rare, and thank God for that this is really rare. But just when it happens, the impact on an individual, which I don't think I appreciated until I really dove into this, besides the obvious loss of liberty and ability to spend time with people that you love and care about, you're not contributing to Social Security. You can't. You're not contributing to your retirement. You can't. You're not working in the most important years that you're building your skills. So then what do? It can't be that we just throw up our hands and say, we made a mistake, go on and live a great life after we locked you up for 20 years. There's got to be some type of compensation that goes towards this. And so, sorry for getting a little bit passionate, but I've spent time with these folks, and it's impossible not to be passionate after you have.
And I appreciate your passion, and I do. And I'm not advocating for doing nothing.
Yes.
But this is, as you began your remarks, admittedly a very complex matter, and
Yes.
maybe it's how we're doing it today is not the best way. I don't know that this is the best way. I just think it deserves some real thoughtful consideration. So that's sort of where I'm coming from.
I appreciate that. Yeah, thank you.
Question from Senator Rhett.
Thank you, Mr. Chairman. I just wanted to say before I came to the Senate, I work with recidivism. I used to go into the local prison, Wright Street, and try and bring people out and help them make that paradigm shift in life. And it's not easy.
Right.
And I can only imagine, God knows, that if somebody served 20, 30, 40 years and come find out that they were innocent, it's even harder. So I think we should at least try and do something to help them to make that transition.
Right. And we're doing it now. We're just doing it through an ad hoc process, so which is important to keep in mind.
Are any other questions from the committee at this time? If you want to sit tight for a second, there's two people signed up to speak, and the first, Ms. Travis just said to say she's for it. Do you come on up? Yeah. Georgia Association of Criminal Defense Lawyers. No stranger.
You know, I got to take off my GACTO hat a little bit and put on my former OLC hat, and have got to tell you that this bill has been written, I did it a number of times, but it never had the thoughtfulness that is in this draft now. The thoughtfulness, the research, the just looking at what the other states do. And I have also, in my OLC days, written those compensation resolutions for people to be compensated. You all don't need to be in the business of trying to figure it out. And this bill actually does give a good framework, good mechanism, and would urge your support of the bill. Thank you.
All right, thank you. And last speaker, Robert Smith, Prosecuting Attorney's Counsel, or Pete Skandalakis. Yes, sir.
Mr. Chairman, thank you very much. Appreciate it. Pete Skandalakis with the Prosecuting Attorneys Council. We also support this bill. We understand Senator Kennedy's concerned about prosecutorial misconduct. One of the problems with trying to throw prosecutorial misconduct in there is how nebulous prosecutorial misconduct is. So when you're looking at actual innocence, that's much easier for a board or a committee to look at and make that decision based upon actual innocence. But I will also say this, any prosecutor who willfully or intentionally does something like that deserves to be disbarred. But I think this is a good bill. I've been dealing with legislative matters for over a decade. Every once in a while, when I'm in the hallway, I'm asked about the process as it was in the past, and I always thought we needed a better process, and this is it. Thank you. Thank you.
All right, question from the committee, Senator Rhett.
Thank you, Mr. Chairman. I just want to say if there's no questions, I'd like to make a motion to vote on the matter, do pass.
All right. There's no one else signed up to speak, though. I'm going to hold on taking a vote on it because I think there's a consensus that we want to do a better process we have now. We do have the luxury of having a process at least now, so we can continue to look at these claims in the next year. But I think I can speak for the entire committee that we want to work with you, Chairman Abstration, whoever else in the House wants to work with us. Soon we all come back. None of us are retiring. So unless we have forced retirement, then maybe we can come together early next year with a version that we all agree is the best way of doing this. Maybe it's this version, but it's just the fact of, as we all know in this room, is preaching to the choir. We have such little time to look at stuff until sometimes we have to look at it. And just the process of where we are. There's a request from some of our members who also aren't in here to spend more time looking at this. So I appreciate your work on it, though.
All right. Thank you.
All right. Thank you. All right. Two more. House Bill 1391, Representative Gunter. And I forgot you were on the agenda again. I'm sorry for making you wait this whole time after you try to present the bill that I tried to present. And
presented your first bill that was your priority.
Right.
But anyway, we're all here together. So.
And hopefully I'm a little better prepared for this one.
Me too.
Okay.
We're working off LC 280447. And you want to introduce your guests?
Yes. Omatai Ali.
Yes.
Is
Ali.
Executive Director of the Public Defenders Council. I invited her to come here with me on this. Very simple bill. It raises the pay of public defenders to be equal with that of the district attorney. Now, and it also does an increase for the classification of public defender 4, which is the most experienced public defender in the office. It raises it from 90% of the public defender's pay to 95%. So it gives them a little bump in pay. This is approved in the budget. It's already there. And this is from a policy standpoint, I'm a former DA. I know that DAs do more work because they handle every case that comes up in their jurisdiction. But the public defender is a key part of being able to handle the cases that come through. And when you don't have experienced people there, you get bogged down in court. It costs the state money, it costs the counties money, and these people are very important. This is an attempt to keep and retain good, experienced attorneys. So that's my pitch. I'll take any questions, and if you want to say anything.
Good afternoon. I think it's almost evening.
It is now.
And it is, and I know our time is well spent, so I'm just going to just ask for your indulgence to thank you. I've been here for almost 2 years now. In 2 years, you all have been very supportive. Our pay is traditionally very, very low. I remember over 32 years when I started as a public defender, my pay was $27,000, just a little bit more than what I made working probably as a manager of a fast food. Fast forward, we're still very low. Now it's become a big deal because now we have a great resignation. We are not able to, we're not competitive. We're not able to retain our employees, and we are just training our employees just to go somewhere else. The taxpayers are losing money. This is not just simply an attempt to make money for our public defenders. This is just to make sure that the people's job is well done and is done on time, so that we don't have people sitting in prison, people having more mental health illnesses, and we don't have the backlog which we pay for. We'll pay for it. Today, we're asking you to please pass this bill. Our CPDs in particular, the chief public defenders, everybody calls them, but they're really circuit public defenders. Their pay was statutorily, it was done, I think, in 2005 at 99. It's still at 107 today. Most of them are making less than some of their supervisors who work in the state. We're asking you, I thank Representative Gunter. Thank you so much for what you've done. And thank all of you for your support over the last 2 years. I'm just asking that you please pass this so that we can retain the best of the best that we have in our offices. Thank you.
All right, thank you, Madam Director. Any questions from the committee? All right, we have two folks that want to speak on the bill. If you all want to step aside just for a second, let them come up. We have James Woodall, Southern Center for Human Rights. Good evening.
Mr. Chairman, Maisie Lynn wants to come up too.
All right, Maisie Lynn.
Thank you.
Gerton from the
Accommodation.
Georgia Association of Criminal Defense Lawyers.
So thank you, Mr. Chairman. We just wanted, well, one, I just wanted to thank the sponsor of this bill, Representative Gunter, for bringing this. This one point that we bring up literally every time we have conversations about criminal legal processes in the state. One of the things I want to name, though, is that when we talk about, where we are when it comes to justice work here in Georgia, whether it's the expansion of powers for the Attorney General or the GBI, oftentimes that burden does fall on public defenders because, as we all know, about 80% of all persons who are impacted by the legal system are indigent. And so we would just ask for favorable consideration of not just pay increases, but making sure that we are also taking into consideration that when there are cases, whether it's evidence, whether it's, caseload or any of those kinds of things, that we make sure that we're taking care of our public defenders as well. And then I know Maisie Lynn wanted to bring some things up as well.
Yes, it's come to our attention that Gachtel's position on this bill was a little confused when we spoke to it in the House. So I just wanted to be abundantly clear that Gachtel supports a pay raise for the circuit public defenders, and we absolutely support the raise for the Tier 4 attorneys. We would also support raises for all of the other frontline defenders who are there is a desire to look and see the landscape of how we pay lawyers in our state government jobs, because public defenders are not paid very well. If you look at the published job descriptions for the level 1 public defender, it starts at $36,000. Now we know in real life most of those attorney ones are receiving somewhere closer to $50,000 when they start, but the published pay rates aren't going to garner a lot of attention from someone exiting law school with loan debt when they see posted $36,000. But that's the statutory scheme, and until you get into the conversations with the agency and learn that, there's actually a little more money on the table, the recruiting problems that we're having and the retention problems that we're having are going to continue because you can't market what's not true. And I'm sorry, I'm so tired, like all of you are.
We're all there, don't worry.
Money.
You have a question I can ask and then you come back.
Ask me a question.
All right, you have a question from Senator Hatchett.
Thank you, Mr. Chairman. I just want to say thank you to the authors for bringing this piece of legislation. I'm in support of this, and also just wanted to thank you for coming to testify. One thing that I also want to look at in the future is pay raises for court-appointed attorneys in conflict cases as well. I think it's been 20, 30 years since they've had any type of raise or compensation increase, and I think they just need someone to advocate down here for them, so something I'll be looking to do next year. But thank you guys for coming to testify, and we look forward to supporting the bill.
Happy to help in any way I can. I did think, go ahead, you do it.
I wanted to name that, Senator Hatchett. Thank you for naming that, because that's going along the lines of what we're talking about, some of the issues that we are seeing continuously in communities all throughout the state. And so if we want to work with you, Senator Hatchett, Chairman Gunter, if we want to work with you over the summer on that, so that way we don't have to keep coming back up here and saying that over and over and over again. So thank you.
I just wanted to get, not that I feel like you really need at this point, but just so you have an anecdote. We had a member of Gachtel who was a public defender in a western part of the state. And after 10 years of service there, as the director was saying, we sort of train people up to leave, basically. After 10 years of service there, he moved to a nearby circuit and took a job, a lateral move, took a job as a assistant district attorney for about $24,000 increase in pay. Am I getting that number right? Yeah. I always back it down to 10, and Joel's like, it's 24. I'm like, I know, but I feel so crazy saying 24. $24,000 difference. And we don't begrudge our friends at PAC and all the prosecutors for, being paid more. We just want parity and equity in the way that we're paying lawyers who are doing the hard work of keeping the legal system going.
All right. Thank you both. Last speaker, Pete Skandalakis, Prosecuting Attorneys Council.
Mr. Chairman, thank you again. I'm here by mistake. And the reason I say that, because right now I could probably be home having dinner with my wife. But I didn't see 1391, excuse me, do I have the right
That's
number?
right.
Yeah, 1391. When I informed one of the District Attorneys Association members who wanted to come speak, it was too late for him to get up here. So he said, would you do it for me? So I'm taking off my PAC hat, and I'm speaking now on behalf of the District Attorneys Association. So it was my mistake, and that's why I'm here.
Okay.
But the District Attorneys Association wants you to know that it's the policy of the legislature to set the pay, and therefore they have no objection to what pay you set as the legislative body. And they're not concerned about what the amount is that you pay. However, they also want you to know that they think the public defenders do deserve a raise. And they think the assistant DAs deserve a raise as well, and sometimes the DAs. And we'll let the judges fend for themselves, okay? But that's the policy, and that's the position of the DAs Association. They have no problem with this bill.
All right. Thank you. That's everyone that signed up to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Hatchett, second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. And who is going to carry this one, Mr. Chairman? Senator Hatchett. That's why you're saying nice things. All right. Thank you. All right. Last bill on the agenda, House Bill 322, a committee substitute. Representative Wiedauer. Oh, yeah. Recognize Senator Kennedy for a motion. And to help speed things up, we're working off a committee substitute that was a department bill that you couldn't figure out how to get through the House, and we agreed to be cooperative and try to help the department in the Senate with LC 480621S.
And we appreciate it, Mr. Chairman.
Yes, sir. Tell us about the bill.
This is for the Office of the Child Advocate. This is to expand their duties to help encourage, support, and outline quality representation for parents and children in certain proceedings. That's the general gist of what this does. Jerry Bruce, director, is with me here tonight. He'll get into just how important it is for them to be able to do this. But the essential element of this is that we have parents and children go in front of court proceedings, and they're being assigned people that aren't trained to represent them properly. But the director, if you mind, go ahead.
Mr. Chairman, thank you, and members of the committee. My name is Jerry Bruce, and I have been the director of the Office of the Child Advocate since June. And as a former juvenile court judge, let me just say that I appreciate you for sitting here for so long. I know what it's like to sit and listen to people make presentations to you and then have to make decisions after a very long day. So thank you. I really appreciate your time, and I'll try to be very cognizant of that. The biggest problem in our juvenile courts is often one that nobody really pays a lot of attention to. Juvenile courts get, and this is just dealing with dependency and termination of parental rights cases. And this has nothing to do with delinquency and status offense cases. Well, actually, it may touch some status offense cases, but not delinquency cases. So the problems that we see are the big blow-up problems when we have child fatalities and we have media attention, and you find that the whole vehicle needs some kind of overhaul. But in fact, we tend not to do the things that help us get better performance out of this vehicle of child welfare law. And that's what this bill aims to do. The biggest, as the former director of the Georgia Supreme Court's Committee on Justice for Children, which is the state's court improvement program, the biggest complaint we had in training all the people who work in juvenile court judges across the state was that the lawyers who represent parents and children in these cases are not properly trained and incentivized. This is something that's been very important to us. I worked on that at J4C, and I'm working on it here at the Office of the Child Advocate in specific ways. Two things that go into that are there's no real incentive to look up to be trained in this area, although since 2014, when the legislature, in large part due to work in this committee, gave us a wonderful new juvenile code in 2014, worthy of Justinian. It's a great code, and it's one of the leading juvenile codes in the country, one to which other people look for as a model. And most of the problem we have in Georgia is not the need to rewrite our juvenile code, but really to fill in areas that need attention. And one of those things is representation. Our attorneys are not well trained. Most of our attorneys are appointed by the courts in front of whom they practice. We've had attorneys come up and tell us after trainings, I'd love to do all this stuff you want me to do. I'd love to advocate. I'd love to appeal, but I will lose my job. My judge won't reappoint me if I do this. There's a fear and a lack of independence by some of the lawyers as well. And most of the lawyers who represent parents and children in Georgia are paid for out of county funds. It's very difficult for counties sometimes to budget for how much it's going to cost with the unpredictable nature of our juvenile court hearings. And so what we've done, in addition to recognizing this problem, at the same time an opportunity has arisen. For the first time ever, about 2 years ago, the federal government changed its rules to allow states to recover money from the Title 4E of the Social Security Act. You probably know we get a lot of money in reimbursements for our foster care system from Title 4E. For the first time a couple of years ago, the feds agreed to allow us to be reimbursed for the cost of representation. And that's a big thing. So we jumped on that immediately by starting a pilot project in Chatham County where one of the things that the federal government has asked us to do, the Children's Bureau, is in order to incentivize and to make sure that we increase our chances of getting this reimbursement money, to try and have some centralized vehicle for training these lawyers so that jurisdictional differences get leveled a little bit. We don't have justice by jurisdiction. Everybody's getting the same kind of training. The best practices that are recognized nationally are being implemented. And so in order to do that, the Office of the Child Advocate entered into a pilot program working with DFACS as the receiver of those 4E funds, the Juvenile Court of Chatham County, and the Chatham County Commissioners. And what we've done is gone there and we have gone in and trained the lawyers. We started with just child attorneys, and we plan to expand to parent attorneys as well and guardians ad litem. And we have trained them specifically on best practices. We've offered them help and oversight in helping to work their caseload. We've worked with their judges to help them get this training. We've provided ongoing training for them, and we're working to develop performance measures for them as well. And we've already started receiving money back from the federal government for the first time for representation, which we're splitting among Chatham County, the entity that's helping us get this money, and a little bit for administrative costs back to the Child Advocate. So Chatham County, which is spending millions of dollars on representation in juvenile court cases and was getting nothing back, is now at least getting some amounts of money back for this. So this is a really important thing that can help us really maximize our ability to recover money from the federal government, increase our outcomes in juvenile court. The state of Washington just recently did a very in-depth study of performance in juvenile court by attorneys, and found that when attorneys were well trained and properly incentivized, that they actually reduced the time in foster care by up to 40%. That's an enormous cost saving. A 40% reduction in time in foster care because of effective advocacy is some real money. So that's an important thing. The final thing is that this version that you have in front of you is different. The wording is very substantially similar, but some important words have been removed and changed in this because the former bill, which is not something my predecessor worked with Representative Wiedauer to put in front of the legislature, had some issues from folks in the judicial branch and some practitioners who worried that it was stepping on the prerogative of the judicial branch in the state Supreme Court to oversee the practice of law. We have removed language that relates to minimum requirements. We have removed language that relates to sort of baseline qualifications to practice. And what we have done is substitute for that recommendations and putting in place statewide performance measures and standards. So this is an implementation of specialized training and best practices on top of the minimum requirements to practice law. If you look at this version, it looks a lot like the authority that the legislature has given the Public Defender Council to train its lawyers properly and make sure that they're qualified to do that work. We have a highly technical area of law in our juvenile code now, and it's one that requires a good deal of competence and expertise. So thank you so much for listening to us this afternoon. I'm happy to answer any questions.
All right, Director, you have a question from Senator Hatchett.
Thank you, Mr. Chairman. I want to make sure I've got the right LC number. Is it 0621S what you're working off of? I guess one of my questions is I see that basically the meat of the bill is between lines 24 and 41, but I'm wondering, and I don't mean this sarcastically or anything like that, but what is this bill actually going to do to help, I guess, better the representation of children? I want to let you know where I'm coming from. And you know, Governor Kemp has made it a priority last year, and we did have a revision of the juvenile code. And I'm not saying this is not something that's needed, but it looks like we may be creating more hoops for certainly juvenile attorneys to jump through. And I know they're so scarce and hard to come by now. And one of the reasons and it's just a coincidence that bill passed right before this, but the funding that's available for these, and you said it's county funds, they can't pay attorneys to do this work, and it's almost like doing charity when you get to a certain extent. But what is this going to do to implement or to better the representation of these children, or is this, and I hate to say it, but are these just more hoops that people are going to have to jump through?
Thank you, Senator. That's a very good question. It is very difficult to practice in this area of law because of low pay, and that cost is borne almost completely across the state by the counties. What we've been able to do in Chatham County by using this kind of model to tell our federal partners, look, we do have what you've asked for. We've centralized our training in this pilot project anyway, and what we want to do now is expand it statewide. We've centralized our training, we've centralized our messaging, we're making sure that we're using statewide performance measures and standards, and we've been able to use some of that 4E money that goes back to the county to pay those lawyers a little bit more than they had before. So we've been able to sweeten the pot a little bit. The counties are getting money back that they weren't getting before. The attorneys are getting more money than they had before. And the attorneys and the judges in that pilot project are telling us that because of the support we've given to them with very intensive training before they started the project, with ongoing support while they're working, and providing them the hope of performance measures to objectify whether they're doing a good job or not, they feel a lot more supported and they seem more likely to stay. The juvenile court judges down there have been extremely happy with the enthusiasm of the lawyers that have come into this pilot project. And that's only one county, one court, and I think we have the ability to spread that across the state. I've got courts asking me every day, can we be your next pilot project? Can we be the next one on your pilot project? We want to make sure that we have a framework in place that will support the federal decisions to send the money back to us. That is, that centralized training, unified messaging, and the implementation of best practices. So I think we're actually supporting those attorneys more. We're giving them things they didn't have before and better equipping them to do the work they have to do.
So if I can...
I was going to say, let me offer this in a more simplified form. This isn't mandating anything. This is an offering of additional training to ensure that the people that are being assigned to these cases are representing them in a quality manner. There's no additional hoops that they're having to adhere to, but in this structure, by adding this duty to the Office of the Child Advocate, allows for the funding that he's talking about, so we can say we've outlined it, but this is not mandating anything additional. This is actually propping them up in a manner so that they can be properly trained.
So I want to make sure I understand. I know it's late, but I think this is an important piece of legislation, so I want to make sure I understand it. So these requirements are necessary in order to receive federal funding?
The Children's Bureau has requested that states, in order to maximize the ability to receive this 4E funding for representation, have the training and the support of those lawyers for whom we're seeking that reimbursement centralized. So that's what this does.
So if I've been a juvenile advocate for 25 years and this goes into effect, I then have to go get more training?
There's actually, the language is extremely intentional here, that it's to support quality legal representation, to make recommendations for training. So there's no mandate here for this sort of thing, but what it does is it puts a mechanism in place so that we can go into the courts that are asking for help and the counties that are asking for help and provide more support. So what we're doing is we're actually, I'm going to some of these jurisdictions, for instance, like in Chatham County, meeting with these lawyers. The judges are giving them time off court. They're not paying to be trained. They're spending a day getting basic, sort of best practices training in juvenile court, and they're going back to court again. So they're not having to go anywhere. They're not having to travel. They're not having to take time off. They're getting paid for being there. So they're just getting additional training. We're trying to make it as painless as possible to implement this.
So is it voluntary training?
Well, if the court opts in and says we want to do this, then the attorneys who work for them agree to undergo this training.
Any attorney that works or operates in the juvenile court for the county?
Well, we're starting this in phases. Yes, ultimately we would like all the attorneys who work in the juvenile courts throughout the state to be thoroughly trained, and we hope incentivized by this money as well. But once again, the idea is not to say, take time off and come to Atlanta to the Bar Center and blow a day or two on some training. It's we're going to you, we're providing this training. It doesn't have to be done, at a particular time or date. We go around the state. I'm leaving here and I'm going to Douglasville, where we're going to be doing a 2-day training for the juvenile court in 3 different counties down there, so that they don't have to take time off. They can all come. They don't have to go somewhere to get that training. So we're going to them, we're supporting them, and we're making this as painless as possible.
Okay.
So yeah, I mean, there would be training requirements for the attorneys who participate in these pilot programs.
And let me be clear on that, though. If they opt to do that, right? So the requirements are for the federal funding.
Yes.
But when it comes to what this does not require any of those to actually participate in that. So it's not mandating an additional hoop.
Yeah.
But this framework of training would have to be implemented to be able to, requiring for the federal money.
Okay, so they opt in, you guys provide support, and in exchange, they are eligible to receive the financial.
Correct.
Yes.
Okay, thank you. I'm sorry for the line of question.
Senator Kennedy.
Thank you, Representative Wiedauer, for bringing this. And just one question I had. Look on line 26, if you would. This is sort of the top of the meat of the bill. Support quality legal representation for parents, so forth and so on, by reviewing the quality of such legal representation, utilizing measurement instruments as appropriate. What does that mean, utilizing measurement instruments as appropriate?
So, answer.
Yeah.
Chairman.
Honestly,
Senator Kennedy,
Yeah.
what we're looking for is trying to find some way. Nationally, there's been a move to try and come up with performance measurements for attorneys working in juvenile court cases. So the state of Washington did that, and they were able to show an amazing savings in time and money by properly training their attorneys and then making sure that they were adhering to those standards. We don't have any of those right now in Georgia. Some states do. My office is working with the Capacity Building Center for Courts, which is part of the Children's Bureau, and is run in cooperation with the ABA and the National Council of Juvenile Family Court Judges to design, in conjunction with conversations with our juvenile court stakeholders throughout the state, and the judges, the lawyers, DFACs, and everybody, a set of broadly acceptable, very basic standards to measure performance.
Okay, thank you.
Senator Jones or Senator Parent? Senator Parent?
Mr. Chairman, I just wanted to say at the appropriate time, I would like to make a motion to pass.
Okay. Anybody else have any questions on the committee? Okay. All right, that's everyone that's signed to speak on the bill. Now is the appropriate time.
Motion to pass, Mr. Chairman.
We have a motion to pass by committee substitute by Senator Parent. We have a second by Senator Jones. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. And who is carrying the bill in the Senate?
Should Brass still be here on day 40? I don't think
Senator
he will.
Brass.
So we'll put that down for now. How about that?
We'll see if he's still here. If not, there's always a second choice, Senator Kennedy.
Thank you, Mr. Chairman and members. Thank you.
Everyone's favorite number 2. Yeah.
Thank you. Appreciate y'all. Thank you for what you do.
Certainly not.
All right, with that, we are adjourned. Thank you, everybody.